please.
My Lords, my Lady, I'm conscious of the limitations on my time. I will deal with the question of service, if I may, in reply. But can I briefly summarise what we say was the likely length of any full hearing, if there would be? And this is based on directions that were made by Mr. Justice Francis. A further directions hearing beyond original one day, a first appointment 1 day, financial dispute resolution appointment 2 days. This is what happened in all family cases, after which there's a neutral evaluation and the parties are under an obligation to negotiate. There's then a post FDR directions hearing 1 day, pre-trial review 1 day, and a final hearing 20 days, based on the time estimate was the basis of the listing. Now, of course, these things are not set in stone. I hope it will give the court an idea that, notwithstanding that an inter-parties hearing might take 2 or 3 days, there will be a lot of court time saved if this case came to an end.
Is that in an order that we can be provided with a copy of?
Yes, my Lord, it is, and I will endeavour to hand a copy in.
So that's about 8 on top of the 20, is it?
It's 20 and then 8, it's 26, 6 on top of 20, so 26 in all.
And how did they arrive at 20 days?
I'm sure it's an estimate on which both parties contribute to, and the judge himself will decide it. But if it takes longer, it will take longer, but that's the amount of time allowed.
20 days for this sort of dispute?
That's what a very experienced family judge said. Yes. Lords, I haven't got time to go through all the various authorities.
1 month of hearing?
Yes. Yes.
This is obviously an exceptional case.
It is an exceptional case.
Is there any thinking about whether what I imagine you're going to say is the disproportion between a full set-aside and a hearing is in a more ordinary type of case?
There may be obviously a relationship with the complication of the issues in either, but what our submission essentially is that although some of these issues will have to be gone in, i.e. the issues on the set-aside in the 20 hearing, there will still be a significant saving. And also, as the Act provides, the respondent has a right not to face this possibility if, in fact, the applicant cannot discharge the onus that rests on her to go through the filter. There are a number of authorities we refer to in our printed case, and I don't think it's necessary for me to go through any of them. They're various first instance judges mostly, with different applications, a different set of facts. There is the case called Zamina and Zimin, which is at 1317, and may I draw particular attention to paragraph 47 of that. And there is a useful decision at first instance, but seeing how these things work out in practice, called M versus W, which is to be found at 1263, and in particular at 1277. And we're all very grateful, I'm sure I speak for my London friends as well, for the case of Ahmed and Mustafa having been drawn to our attention by the court. A decision of the Court of Appeal and the judgment given by the President of the Family Division. And it was concerned essentially with an anti-suit matter, but there is a useful passage at paragraphs 21 and 22 when the argument was, well, because of Agbaji and because of Part 3, that should colour the approach. And he says this: although Mr. Southgate makes an attractive and strong case, I'm not persuaded that the judge lacked jurisdiction to grant an anti-suit injunction in his proceedings. Plainly, as the case law established, the High Court does have jurisdiction to restrain a litigant in person from relitigating matters in a foreign jurisdiction where it's unconscionable to do so. Mr. Southgate easily establishes that the proceedings does not of itself render an attempt unconscionable. Indeed, Agbaji established that follow-on jurisdiction as represented by Part 3 is internationally acceptable, but that state of affairs does not rule out the existence of cases where on the facts of the case it is indeed unconscionable to contemplate either party seeking to have the very same issues. To some extent, those words are echoed in section 16.2d and section 16.2e, although not exactly those words, of the Act. and certainly consistent with it. Otherwise, I'd like to come, if I may, to Mr. Justice Cohen's judgment on the inter partes, which he delivered on the 8th of November 2019. I'm conscious of the fact that the court will have read his careful judgment. But may I just highlight one or two points in there? He summarises the different cases for the wife, and indeed what she says about the law and the application for leave. He also deals with Russian law at 245, paragraph 20, about what is joint marital property, and makes a useful conclusion from paragraph 21 about what the Russian court's approach is to these type of cases and their exclusion of the trust concept. He refers to the fact at paragraph 35, 249, that in his view, in every instance, the Russian courts have consistently and properly applied Russian law. And he fails to understand why he could have been told in the statement that it was the same as in England. He then deals with misrepresentations, as he describes it, of the high duty of candour. This is at 251. And he directs himself to particular paragraphs of Akbarji and various factual differences that he now appreciated were not quite right. He refers to Zemina and paragraph 47, to which I've drawn the court's attention to. And he then comes to discussion of the matter. And we can see at page 40, paragraph 46, 252.
And you might not have needed to spend 2 days on this if he hadn't had to waste half the time deciding whether what all hadn't been said and whether it's correct the first time round. He'd just gone on with them deciding whether he should give leave or he shouldn't.
Well, of course, that's what he did when he finally came to the de novo hearing. But I respectfully agree with my lord that he had to do that, so he thought.
Well, I know he thought he had, because that's what was said in that observation
That's why it's a lengthy judgment. But he does, in our submission, go through all the appropriate hoops. He decides, for reasons in accordance with the law, that he can set it aside, and then he makes. He emphasises certain passages in Akbarji, which he doesn't appear fully to have appreciated. He acknowledges that minor misrepresentations wouldn't be enough, but he, of course, says that they were major misrepresentations. And what he says, importantly, at 256 is this, paragraph 59, I am in no doubt that if I had the full picture before me, I would not have granted W leave to make her application. I'm further satisfied the grant of leave was given as a result of material misleading of the court, however intentional that might have been. And he then goes to deal with the application of leave, the application of the section 16 provisions, and he refers to all of these points under the maintenance regulation, which I'm not going to trouble you with, and comes clearly to the conclusion, paragraph 85, accepting that it was a small award by English standards, and if they'd been resident here, would have awarded a vastly higher sum. But Mr. Howard accepts the relevance of W's connection, and inevitably the weakness would limit her award. He is against the idea of allowing this matter to proceed on a limited basis. That's paragraph 89. And he says, I'm satisfied that there is no solid basis, because substantial has been described as being solid for making an award, and therefore exceeds the application and dismissed the application to leave to bring forward a part 3. Now, the matter then went to the Court of Appeal, as the court knows, and it appeared that the Court of Appeal might be going to reconsider this whole matter, but they didn't, in fact. They really approached the decision on the basis that the law was as it appeared to be, insofar as it was ascertainable, from Akbarji and from Traversa and Freddie. And In fact, of course, Mr. Justice Cohen, when describing I should have referred to this, but it's apparent from his judgment, describing the evolution of the practice, said that it had developed and that he hadn't been aware of fully of the 2017 provisions at the time. We can't know precisely what he knew at the ex parte time, but he himself seems to think that it had developed, which of course it had in a number of respects. The exact interpretation, I accept, is not perhaps as clear as it might be. It is perhaps worth particularly to looking at the Court of Appeal what they say at page 208, paragraph 33. In my judgment, the judge's instinct, as one would expect for a judge of his experience of financial remedies case, was absolutely right. And this was an application which, by virtue of Rule 88.25, should have been heard inter partes. Had that been the case, the judge may or may not have given permission, but that is not the test for setting aside an earlier grant of leave. And she then deprecates the amount of time that was spent on this, and even criticises the court for spending too much, the Court of Appeal itself for spending too much time on the matter, because it isn't consistent with the dicta, which suggested that there should be a swift hearing of the matter. For example, at paragraph 50, page 213, the approach to the appeal has been much the same. The court permitted on reflection far too extensive argument about the rights and wrongs. And the court's not charged with rehearing the case. And in my judgment, the judge was in error, embarking on a wholesale examination of the evidence on the way he did. Agbaji remains good law. And the appeal was not, however, specifically directed at what was, in my judgment, a significant procedural irregularity, as the principal focus was on the submission the judge had erred in concluding that he'd been misled on the evidence before him. The two issues, however, interleave. True, as it is argued, not only the judge was not misled, but also that the judge, having failed to adjourn the matter, wrongly reached adverse conclusions and found them to be misled without having heard oral evidence from the parties or the cross-examination of the expert witnesses. And so...
When does cross-examination of expert witnesses in relation to the matters in issue, is that the matters as to whether he had been misled, or is that...
It's somewhat unclear, but I think she was postulating the fact there'd be cross-examination of witnesses as to foreign law, witnesses as to questions of fact insofar as they were relevant. But I have to confess some uncertainty what is entirely meant by that. So the surprising conclusion reached at 73 is these examples, referring to the various examples as alleged misrepresentations, expose one of the dangers of ex parte hearings, in complex cases, quite so. Once the full picture emerges at trial with the benefit of inter partes submissions and oral evidence, a judge may well take the view that he'd known all that she or she does now, he would not have granted permission. But that does not mean that the judge has necessarily been misled at the initial ex parte hearing. And she says at paragraph 86, it's understandable that the judge may consider again when he has an inter partes hearing what the right answer is. But she says, as the law presently stands, however, a set-aside hearing is not a return date. Now, we submit that that is really an unsatisfactory state of affairs. And then 87, it may be the judge would refuse permission, but that is not the issue on the appeal. She finishes with some suggestion that there will be a full hearing unless the parties can reach some sort of compromise. And finally, at paragraph 93, she says, by no means all Part 3 cases relate to families with massive or even substantial wealth, and it's important that the cohort of persons for whom Part 3 proceedings were designed have access to a straightforward and cohesive procedure. Looking more broadly, the complexities could well benefit from consideration of the Law Commission. As we put in our case, the Law Commission is considering generally, but it specifically excludes this particular area. So we cannot say, well, the Law Commission will sort this out. So I would rather canter through those authorities, but clearly both those judgments repay careful consideration. Our submission is that the decision of the Court of Appeal has left the law in a most unsatisfactory state. The judicial guidance from the cases suggests that applications for leave should be, inverted commas, appropriately short, of itself a somewhat question-begging observation. And so apparently should applications to set aside, because a knockout blow will need much more, will not need much elaboration. It's possible that this court is rather underwhelmed by the fact that this pocket of jurisprudence is full of homely phrases like knockout blow, top up, second bite of the cherry, and even the word lacuna in this context, which do not in fact illuminate the analysis very much. In particular, the concept of a knockout blow. The respondent's case suggests that, to borrow Lord Justice Mumby's phrase, it should not take all that long. The fact that the set-aside hearing was listed for 3 days, 1 day for reading, shows, it says, that there was no knockout blow. So it appears that if one extends the metaphor, the knockout has to take place in the first round. Cohen J. refused permission, and he summarised neatly why he dismissed the wife's application. And we can see that at EF 266. There is a handwritten version and there's an agreed typed version, which we get at 266, where at the top of the page he gives brief reasons for decision to allow or refuse permission. And if I could invite the court to read that. He concludes by saying, I believe I apply. Sorry, it's 266, my lady.
Yes.
It's a typed version of what we can find at 264 and 263.
It's what's in the box.
It's the top box and the bottom box. Mm. And he concludes by saying, I believe I applied the law properly to the facts as they were later put to me on a full inter partes basis, rather than I understood them to be at the first hearing. When the Court of Appeal gave permission to appeal, it seemed that the court was going to review the law in this area. And we can see that from 234, where we see the terms of the permission to appeal. 234, the reasons for giving appeal, leave to appeal, permission to appeal, were regardless of the merits of the applicant's case, the matter falls within CPR 5261B, as there is a compelling reason to hear the appeal in order to consider applications to set aside leave which are being granted ex parte generally and what can or should amount to a so-called knockout blow, and also the proper interpretation of 16.3 of the 1984 Act. They didn't, in our respectful submission, quite follow through that permission in their approach.
But it's now accepted that the maintenance regulations are not in point.
No, the position with the maintenance regulations, my lady, is that they were argued below, and there is still an outstanding appeal in relation to that. This court did not want any submissions on that particular issue. We did provide submissions in writing and I think orally at one stage to the lower courts. We would be happy, whatever the court directs, to supply written submissions on the maintenance regulation within short order if that's a matter that commends itself to the court. But it's not within the scope of the argument that this court has asked us to address.
That was ruled on, as I recall, as a preliminary question about what form this hearing should take.
Yes. So the Court of Appeal decided that Cohen J had very limited scope for setting aside once he'd made his ex parte order. Different if the decision had been made inter partes, which he should have done. He should have heard it inter partes according to the Court of Appeal. It seems that it's not enough for a judge to say that once he or she has the full picture, then they can make a decision based on a hearing, however long it is appropriate. In fact, the judge expressly found that he had been misled and gave cogent reasons for that conclusion. And on that basis, he was entitled to proceed as he did, to hear the matter as he would have done if he had followed his initial instincts, which the Court of Appeal said were the right ones.
If he had the inter partes hearing and granted leave, is there still the possibility of applying to set that leave aside? And what would the test be then?
It appears that if he had granted leave,
After the inter-parties hearing? No, yes, if he has an inter-parties hearing on leave, is there then still the ability for the respondent to apply to that court to set aside the leave, or do they then have to appeal?
they have to appeal. So.
Right, so the set-aside is only in respect of leave granted ex parte?
They can't have a second bite at the cherry, to use that.
Yeah. So
So-
the question is, what is the test on a set-aside, given that we're talking about leave that was granted at an ex parte hearing?
Yes, that's the issue.
Yeah.
So he found he had been misled and gave cogent reasons for that conclusion. On that basis, we say what he did, which was to separate out his setting aside consideration inter partes and then the de novo application as if there were, as it were, had been inter partes, was a correct way to proceed. And if an experienced judge said he was misled, it's surprising, we submit, that the Court of Appeal were able to conclude he was not objectively misled. And the submissions from the respondent seem to amount to saying, well, even if he was misled, he wasn't sufficiently misled.
Still don't understand you to have a ground of appeal.
Well, we will say that comes within grounds 2 and 3 of the grounds of appeal. The result of the misstep is there'll be more substantial litigation than what is said to be the largest ever case for the family division. And of course, the husband will be at the mercy of the OFSI as to the funding of any legal costs. And all this litigation will be the result of an application from the wife whose connection with this country is, to use Cohen Jay's words, recent and modest. Many of the allegations that were made about the Russian judicial system have been found by Justice Cohen to be baseless. My client is sad that his relationship with some of his children from his first marriage is not as good as it was. His approach to this litigation has been to pay everything he has been ordered to pay, to honour costs orders when made against him, always in full. That applies not only to the Russian proceedings, but to proceedings here. He respects the courts here and has complied with all orders. His connection with this country is not something that even the respondent can say is at all substantial or exists at all. The strongest point, apparently, from the respondent's case is that one of his business contracts contains a clause giving jurisdiction to the courts here. I very much doubt that Parliament intended this would amount to a substantial connection. My client's wish is that he can, after all these years, have a life that does not involve endless litigation with his former wife, and allowing this appeal should enable that to happen. There is, of course, a point of law which is important and beyond the interests of the parties in this case. This is the first case where the procedure for leave applications under the 1984 Act has directly come before this court. Further guidance about the need and appropriate cases for inter-parties hearings would certainly be beneficial. And the most recent guidance from the President of the Family Courts has to some extent anticipated this. And may I take the court to EF 2194. This was the guidance given by the President in May 2021, following the 2018 guidance. And helpfully, the changes can be seen in red. And in particular, we can see at 2198 the relevant additions to that 2018 rules. And there is to be a gatekeeper system involving a district judge. We see that letter D, we're looking at 2198 now, when determining the allocation of the application, the gatekeeper will also consider whether the permission application should be heard on notice to the respondent pursuant to 825.3. If the gatekeeper does not decide to allocate the application to the High Court judge, he or she will normally determine whether the case is sufficiently complex or borderline to warrant the permission hearing being heard on notice. and there's reference to what is the Court of Appeal's decision there. And so to some extent there's an anticipation, but clearly practitioners and parties would benefit from further clarification. The knockout blow approach to set aside hearings is capable, as here, of causing real injustice. It also runs counter to the purpose of the 1984 Act. The alleviation of hardship, expression used, has, if the Court of Appeal's decision is affirmed, seemed rather to have disappeared from the analysis. My Lords, we submit that the decision and the procedure that was adopted here risks encouraging forum shopping by those who regard our courts as generous. And our submission is that was never the purpose of the legislation. My Lords, my Lady, those are our submissions.
Thank you, Lord Vokes. Mr. Howard.
Thank you, my Lord, my Lady. Can I first of all make a few preliminary points that mostly arise out of what's been discussed today? In the background, obviously much of what my learned friend has said is controversial, including, of course, there is a dispute about the date of separation. And just to give you the reference, it's to what is page 167, footnote 27, which sets out where my client's case is. Secondly, there was much discussion about a fuller picture being available at any hypothetical inter-partes hearing. Well, although there are disputes in this case, the important points are not really gainsaid by the husband. Namely, that my client received less than 1% of the total wealth, which was of the order of 20 billion, that he is the beneficial owner of the 20 billion or whatever it is. Her connection is, as she said, which is that she intended to be here permanently from 2014 and has rarely been based here ever since, that her Russian connection is totally severed and has been severed since 2013, she says for good reason, magnified now by the fact that her then very elderly mother, who she had to visit, aged 99, is now deceased, and that she was not able to make a needs claim in Russia, and that her needs claim in this jurisdiction, as well as her sharing claim, would be worth considerably more. Now, that was obvious to Mr. Justice Cohen at the ex parte hearing. He didn't really fully refer to it when it became the set-aside hearing, but it is all highly relevant, and it goes to the fact that the fuller picture, in the big sense, really didn't require an inter-partes hearing. But of course, all of this goes to ground 13. My learned friend has trespassed into ground 13, but that is not before the court today. The next point I want...
What's ground 13? Sorry to the uninitiated.
Whether,
you don't have it at the back.
Well, that was the other preliminary ruling that this court made, that the question of whether he was wrong to re-grant leave, whether he was wrong to re-grant leave.
I see.
And of course, a lot of my learned friend has said has trespassed on that, which we were told not to make submissions on, and directions were going to be given afterwards.
Where do we see that, Mr. Howard?
Sorry?
Where do we see that that direction was given?
What? 85. Page 85. Grounds 12 is the maintenance regulation point. Grounds 13 is the re-grant of leave. And, I mean, I'm not going to make submissions, but we say, and my learned friend has heavily relied upon it, that when he came in the second part of his judgment to decide whether to or not to re-grant leave, he fell into error, and that was ground 13 of our appeal, which, as you know, the Court of Appeal did not rule on because they did not need to, and we made a submission that seeking the court's guidance as to whether we should cover ground 13, and we were told no.
I'm terribly sorry for taking up your time, but whereabouts do we find grounds 12 and 13?
Is it in the application for permission to appeal?
The application for permission to appeal.
Pages 3 to 41 of the bundle.
3, 4.
Yeah, thank you very much indeed.
Yes. So, I mean, obviously, but I mean, we do.
It won't be in the original application for permission to appeal because that was made by the appellant. I think what happened was that you then, at some stage leading up to the hearing, said you wanted to introduce those grounds into the hearing as a respondent. And there was a question about whether the appeal should be broadened to encompass not only the appeal, but your cross-appeal, if you like. And it was decided that that should await the outcome of the appeal.
It wasn't a cross-appeal.
Not as such, but no. That's essentially what it amounts to.
I mean, what happened was we appealed to the Court of Appeal. We were given leave on all grounds, including ground 12 and 13. 321. What? 321, it's.
321.
321. We were given leave on all our grounds.
In this court, it's a respondent's notice type of point that the Court of Appeal came to the right conclusion for other reasons than the ones they gave.
But the ground 13 is set out at page 321.
So ground 13 is a reference to the grounds of appeal to the Court of Appeal, not
yes,
the grounds of appeal.
Which they didn't resolve. And then guidance was sought by us as to whether we should cover ground 13. The husband said that we should, and the court ruled that it wasn't necessary at this stage. So, I mean, we do say that he was wrong to re-grant leave, but I'm not dealing with that. I wanted to deal, and Mr. Justice Francis...
Wrong not to.
Sorry?
It's wrong not to re-grant leave.
Sorry? Wrong not to, yes.
Not.
Yes, that's right. The original judge was wrong not to re-grant leave.
Yes.
Yeah.
Yes, I'm sorry. The next point I wanted to make, Mr. Justice Francis's order of the 20th of May, which is going to be handed in 2022. The position is that the estimate of 20 days was a complete guesstimate by the advocates in order to secure a listing, because the debate was whether we would be listed. Whether that is too long would be sorted out at the first appointment. But what is quite significant is that Mr. Justice Francis proceeded with the case on the basis of abbreviated disclosure and no expert evidence. He said there should be an abbreviated Form E, a capital schedule. Not all of the Form E should be filled in, which is the form preparatory to any application, and that he didn't rule there should be any expert evidence. And it may well be there won't be, because although the sums are very big here, the valuation of Norris Nickel will be determined by the share price, which is a matter of public record, as is, of course, the amount of dividends. And we capped our case based upon as a maximum, the value of the Norris Nickel shares and the dividends since 2014.
Is it a Russian company, this company?
It is, isn't it? The underlying company is Russian, but the holding company was in Cyprus,
Right.
through which he held Norris.
So all the argument is about allocation of Russian assets.
Well, except
Russian
Interos
people.
was a Cypriot company,
All right.
yes, the holding company.
But insofar as as it's relevant to consider under Section 16, the extent to which the availability in England and Wales of any property against which the order could be made, or whether it's likely to be enforceable, what is there that, was there disclosure as to that ordered?
Well, I assume you'd be mentioning it if there was any property here, but there isn't any, is there?
What was ordered was there would be an abbreviated Form E, and then we would look at it, and there'd be a capital schedule. And that's the way you go about it, obviously in the family division. You have for financial provision, you have the Form E, which is a document which is you fill in, and then, of course, we would consider that point in the light of it. I mean, what we do know is that he owns a company called Interos, which was based in Cyprus, and then that owns Norris Nickel. But certainly, we weren't saying necessarily there were any assets in England, but I mean, we are waiting for the abbreviated Form E. And as far as enforcement is concerned, you've heard my learned friend said that the husband respects the English courts and he has complied with the orders. He's not someone who has not complied with orders. So we, on that basis, are confident that if we do get an eventual order under Part 3, it will be discharged in full. What is an issue at the moment is a very preliminary stage as to whether we should have leave. But
that doesn't make it enforceable, does it? It just means that he may be likely voluntarily to pay it.
There's no evidence either way about enforceability. I mean, the position is that we decided that we'd rather keep our powder dry about enforceability in case. But it didn't really feature in either of the two hearings, the enforceability point.
Is the judge required to consider that factor?
Yes, it's one of the cocktail of considerations under Section 16.
And there was literally no evidence from either side?
There was no evidence from either side, except the husband said that he respected the English court. But my point is about what I was trying to make about the long hearing is that it may well be that it doesn't have to be expert evidence, and it may well be we don't have to have a 20-day hearing. I would like to confirm that we do not need leave to serve the husband out of the jurisdiction in the family division, and I accept what my learned friend says. The right rule is FPR 6.41. There was also, after the order was, as it were, made at the ex-parte hearing, there was a discussion about service and the right way to serve him and the husband, and that was done, and it brought it to his attention. The position, therefore, is that unlike in other jurisdictions, say, involving Russians in a non-family context, A, we don't have to serve out of the jurisdiction, and there is no problem about that, and there is certainly jurisdiction to entertain this claim because of Section 15 of the Act. My client was habitually resident for at least a year before she made the application. So basic jurisdiction is not an issue.
Presumably, if there's an inter-partes hearing, then there will be service of the application before the hearing.
The application has been served.
No, but I'm just thinking about the general procedure. Because if you're otherwise, after an inter-partes hearing, you'll be able to apply to set it aside, which can't be right. So I assume the practice is, but tell me because you are the expert on this, that if the judge decides he wants an inter-partes hearing, then arrangement is made to serve the application before the inter-partes hearing.
Yes. But in this case, there was an ex-parte hearing, and it was ordered to be served on it.
After the hearing?
After the hearing.
Yes, exactly.
And that was discussed during the transcript at certain length, how that would be affected, so it would come to his attention, and it did come to his attention.
Hence, the opportunity to set aside rule is then engaged, which it wouldn't otherwise be. Exactly.
So there was extensive discussions about service. And in answer to my lady's point, if FPR 18.10 applies, the husband will know about an unsuccessful application.
Well, does it apply?
Well,
nobody knows. Okay.
Probably is my. I mean, it looks as though it does, yes. But I mean, I'm not sure that's ever been considered. Then the next.
Sorry, I do apologise. What was the reasoning behind not requiring leave to serve out of the jurisdiction? You're obviously correct. The rules don't require leave. But do you know the reasoning behind that?
Can I consider that overnight? I don't know. I'd be, as it were, prevaricating if I said I did. I do not know the reason. And Mr. Nagbal is shaking his head as well.
Yeah, okay.
It's been a long-standing as it were, practice and rule.
It may be that generally the husband's, nobody knows where he's gone. He's gone to some foreign jurisdiction, he's pronounced, he's got this divorce, who knows where he is? Maybe is that the...
Well, he may be living abroad anyway.
Yes.
Well, in deciding to grant leave to bring the proceedings, the Court of Appeal the court will have traversed the sort of ground that a civil court would ordinarily traverse in deciding whether to give permission to serve out. In particular, appropriate venue under Section 16. So one assumes that having gone through that, it would be extraordinary if they have to apply leave again to serve out.
Yes.
Although there may be all kinds of problems in finding.
But it's the rule isn't confined to Part 3 cases. It would be a rule that applies to serving financial provision proceedings after a divorce. Or it's just that it's not required in the family division. It's where the practice is different. It's as simple as that. And it has been for as long as I can remember. But I mean, you could have if there hadn't been a Russian decree here and a Russian order, my client could have started divorce proceedings here after a year. And then it would have been exactly the same. Because habitual residence for 1 year would have given rise to her having a right to divorce her. So it wouldn't have been any different. And then she would have had to serve him in Russia. But of course she couldn't do that because of what was discussed in Quasi. There was a foreign decree.
Yeah.
And that's why it's Part 13. A question was raised, quite an important one, was substantial ground discussed by the Law Commission? Well, my friend didn't think it was, but it was. Could we turn to page 1044, which we say also throws some light on the ex parte procedure?
Sorry, page number again?
Sorry, 1044. It's 2.5. Issue before the court on the hearing of an application for leave will be whether the applicant has established a substantial ground for the making of an application. Essentially, this will involve the court in estimating, on the basis of the applicant's uncontroverted statements, his prospects of success in satisfying the court that it would be appropriate for an order for financial relief to be made. The fact that it was recommended that it would be on the basis of uncontroverted statements, we say, diminishes the need for and any unfairness of not having an inter partes hearing. The essential difference between the application for leave and the application of the substantive application will be twofold. First, on the application for leave, the court will normally only have one side of the story before it, so ex parte is the norm, but you can have an inter partes hearing, and will have to proceed on the basis of the applicant's evidence alone. On the hearing of the substantive application, the court will hear both sides, unless the respondent decides not to attend. Secondly, the burden on the applicant will inevitably be somewhat lower at the stage of the application for leave than will be the case on the hearing of the substantive application. At the first stage, the applicant will merely have to satisfy the court that there is a substantial ground for making the application. At the final stage, he will have to satisfy the court that it is in all the circumstances appropriate that an order is made. Even after he's obtained leave, the applicant still has to satisfy the court that it's appropriate to make an order. The test of appropriateness is necessarily an imprecise one. So that is making clear that this husband has every right, and that is clear from the statute, at the trial to run all the Section 16 points. And it is also indicating that what the Law Commission had in mind was that the leave process should be on the basis of uncontroverted statements, normally one-sided, for the applicant to show what her prospects of success were. And we say that is precisely the approach that the Lord Collins recommended and indeed has been followed in the family division and was followed, we say, by Mr. Justice Cohen at first instance when he considered, we say, all the salient factors including the negative ones about the lack of connection of Russia in the marriage. He fed in what we call the lacuna point, the connection point, and he considered and he came to the view that my client had a substantial ground for making the application, and it was perfectly appropriate. So it was. The next, as it were, preliminary point is that I want to emphasise that the concept of substantial connection is not in the statute. It's just not there. It is what the statute makes clear is that connection is not the sole lodestar here. It is one of the cocktail of considerations.
But what business do the English courts have making orders against somebody who has no substantial connection with this country, whose marriage has none, who has no property here, and where the applicant has only moved here after the marriage?
Well, the answer to that is the statute makes it clear that such an application should be entertained, and it should be considered from the leave stage, not just on the basis of connections, but also...
There's nothing in the statute that says the court can't take the position that if the case has no substantial connection with this country, the English courts have got no business in correcting wrongs that have maybe allegedly occurred elsewhere.
Well, the statute makes it clear, of course, that an order in a foreign jurisdiction does not preclude the English court making an order.
Absolutely.
And so that is one of the... So there is power to make a second order, and then the court says you don't look at the connection solely. And with the greatest respect to your lordship's point would seem to me is that you are saying that connection is really the sole criteria. It's
not at all. I'm just saying that there must surely be a minimum level of connection which you have to establish, just on basic principles of international comity of jurisdiction, before the English court can be in the business of making orders on facts which prima facie have nothing to do with this country.
Well,
that's the whole basis of international jurisdiction in disputes, that some level of connection it has to be surpassed to justify the courts getting involved. And I fail to see how the fact that the applicant has moved here just before the start of the proceedings can be of itself sufficient to get over that hurdle.
Well, of course, the working party did... where's paragraph 36? Address this point. What? If you look, my lord, at our written case... sorry, I'm lost.
The working party didn't say that you had to have connection before your divorce.
Yeah, exactly.
And
it's paragraph 36, page 147 of our case. The Law Commission expressly acknowledged that there may be a number of cases where there's no connection with this country until after the foreign divorce. In some such cases where a real connection arises subsequently, a court should be empowered to entertain proceedings. That was the recommendation. And it isn't just...
If I could, sorry,
my lord.
In relation to the question of connection, do you accept that deliberately coming in order to this jurisdiction, in order, the sole reason or the predominant reason or the dominant reason is to bring a claim, that wouldn't be a connection within, that would be a manipulation of the system rather than a connection with this country? That would require oral evidence. I appreciate that, but I was looking at the text. And it would require oral evidence at a trial. If at trial... That. I'm sorry for interrupting. Sorry, I appreciate that that sort of finding, you say, requires oral evidence. But do you accept that as a test? That if you deliberately manipulate in order to create a connection, that is not a connection within the meaning of the 1984 Act? That could lead to a finding that was not a real connection and then would go to the connection point. Yeah. But,
well, it would be worse than that. It would be an abuse of the process of the court, wouldn't it? if you just moved here with the sole reason of using a process of the court that otherwise wouldn't possibly be available to you?
Well, it's very fact-specific. I mean, if at the trial, for instance, it came to the judge made a finding because of investigation that a woman came to this country. She never had really any intention to live in this country. She had a home in America, say, that she was going to live in, or Canada, and that's where she really intended to live, and the husband was able to produce letters with her children to show, well, I'm just going through this charade. Well, clearly that might be an abuse, but that is far removed from this case.
Well, I can't see actually how it's any better or different, really, if somebody just comes here because they like living here. Why should that possibly be enough to interest the English courts in making good a wrong that they've suffered somewhere else?
Because the court is enjoined to look at the connection, and I accept that might require an investigation as to whether that connection was real or a charade. But if it was a real connection, and then you looked into the connections with Russia, and the evidence was, as we say it is here, that my client has severed her connections with Russia for very good reason, that she really doesn't have now, and indeed then, any good reason to go back to Russia. She does have a formidable connection with this country. It's her home. And the Law Commission made it clear, and indeed the statute doesn't say otherwise, that all you do is look at the connection in the light of all the other circumstances. It isn't the sole consideration under the statute. And if it was, then the statute would say so. If it was that you only looked at connection during the marriage, then you'd say that, but it doesn't. The Scottish system was obviously that there would be a condition of connection of the marriage, but that is not the route that the English statute went along. It went along, you look at connection, full stop, with this jurisdiction and connection with any other jurisdiction. And my client is able to say, and even more so, because we're rather artificially confining this to 2019 or 2018 when my client made her application. We are now 5 years on. And really, any suggestion that she's a forum shopper or a divorce tourist, no evidence has been adduced that other than now she has had her base here, has intended to live here for nearly a decade. So we say it is a strong connection. And of course...
well, that would be tested if the proceedings had come to an end, but as long as she's got the prospect of winning millions of dollars, maybe $1 billion or something, she's got a pretty good encouragement to live here.
Well, my lord, I mean, this is all going into issues that can only be canvassed at trial. You cannot proceed on the basis of a leave application to assert against my client that she's a divorce tourist, to use the judge's. And the judge made that finding, which was totally unjustified. There wasn't a shred of evidence that she came here just to claim. She came here, her marriage broke down, she had good reason to leave Russia.
Well, there was a shred of evidence because it emerged that she'd taken legal advice from divorce lawyers before she moved here.
Well, but, I mean, the Court of Appeal dealt with that. I mean, you know, in order to gainsay that had anything to do with it, you'd have to look at, she'd have to disclose the advice, and it would be wrong to draw inferences from that. That was dealt with in the Court of Appeal, and there's no appeal about that. But the position is that she did come here. She has had a home here, an owned home here, now for 9 years, 9.5 years, and it is her home, and she does not go back to Russia. And so we would say that there's a strong connection, and you don't just look at her connection to this country, you look at her connection to Russia. And of course there is the case of AA and BB. In that case, the wife there came to this country after the marriage broke down. She had been here roughly the same time, exactly the same sort of lacuna as we call it, and she was given leave to make her application.
Well, he may be coming to the case, but there's quite a big difference in that there, I think the court in Slovenia took the view it had no jurisdiction over assets outside Slovenia.
Yes. Well, I mean, my learned friends have gone into a great deal in the Russian proceedings, but I mean, what it came to, despite all these hearings, there was one central point, that the Russian court were not empowered, so they found, to take into account anything that the husband beneficially owned, which is, we say, the difference between that and AA and BB is a distinction without a difference. It's just the same. It wasn't that the Russian court decided, oh well, as a matter of discretion, the husband can keep his beneficially owned assets, and you can't have them. It was, we can't consider them because Article 34 confines us to what is it actually in his name or your name. And it was exactly the same with the matrimonial home. A very substantial property, she got none of it, purchased, she says, and not contradicted, or built for $150 million, and she got none of it because it was in the name, so she said, of a nominee of the husband, and the court said can't deal with it because he's not the actual legal owner.
It just seems extraordinary to me that there's an argument here about how the matrimonial home in Russia should be distributed, when the Russian courts have already decided that point in extensive litigation between two people who are Russian nationals and conducted their entire marriage in Russia. And now the English court's being asked to say that actually their allocation of that property should be revised.
Because the English court, because the Russian order is not the end of the story as far as the English court is concerned, and that is clear from section 13 of the Act.
But it really is an invitation to make us a court of international reach, isn't it?
No, because there are restrictions. There are the restrictions about habitual residence, and there are restrictions in the leave. If, of course, the court decides, having taken everything into account at the final hearing, it's not appropriate to make an order, then the husband will prevail. But at this stage, we are dealing with a case where there was leave granted, we say perfectly properly, and then there's, we say, a perfectly proper test to set it aside, which the husband doesn't come within. And obviously, I'm not going to go any more on to ground 13, which is not, but we say that this is a solid case for granting leave. And whether or not at the final hearing it is decided on the facts of this case that the court should not, as it were, supplement what happened in Russia, then my client will lose. But we say it's a strong case.
I suppose that the courts in England would divide up the assets held, no matter where they were in the world, including a matrimonial home in Russia.
Yes.
If your client had come here and resided here 1 year before issuing divorce proceedings.
Yes.
And that is commonplace. So that that's what the statute says, and it's consistent with the Matrimonial Causes Act 1973.
It is. If my client, if there'd been no Russian divorce, my client had just come here. By 2018, she could have initiated divorce proceedings in this country. She would have got a needs-based claim, which she couldn't get in Russia, which is another lacuna. She would have got a sharing claim. And there would have been no difficulty about that. And the English court would not say, oh, well, we're not going to deal with this because you're Russians, you've always lived in Russia. There would be jurisdiction. And it's just arbitrary. The only difference here, we say, there has been a Russian divorce in which my client did not get justice. And she has suffered hardship, injustice. She doesn't have to prove that, but if it occurs, as Agbarji makes clear, that is relevant to the exercise of the jurisdiction, and that injustice can be put right. And if one looks at Agbarji, there are some quite interesting passages that I did want to refer to. One, that were not referred to in the Supreme Court. The hardship, which my learned friend didn't read out.
Just going back to if the divorce had been commenced in this jurisdiction,
Yes.
She wouldn't have had to get leave at all.
No.
And she would just serve the proceedings on the husband in Russia.
Yes.
And if, by way of contrast, if the both of the individuals who were subject of a foreign divorce happened to reside in this country, and there still is a requirement to give leave, which would be an unusual thing to do when you're commencing proceedings, because usually you can just commence proceedings against whomsoever you wish at any stage you wish. And so does that affect the meaning of the word substantial at all?
What if the hypothetical that both the parties...
The hypothetical, both of the parties are here, and ordinarily you can sue whoever you wish to sue.
Well, the service would not make any difference whether the husband was in or out. What would be the difference is, of course, there would be more to say about his connection in those circumstances.
Yeah, I know.
But you would still have to get leave.
You still have to get leave.
You'd still have to get leave under Section 13 of the Act.
Yeah.
But I mean, your task would no doubt be easier because the husband would not be able to say, as this does here, well, I'm in Russia and it's nothing to do with me.
Yeah.
Yeah. So that would be the difference in that scenario. I mean, obviously you'd have the husband's connection as well as your own. But it wouldn't stop the basic jurisdiction under Section 15 because you'd have that because of your habitual residence. But I wanted to highlight, it's 1199, hardship, injustice, exceptionality, and an award of the minimum extent necessary to remedy the justice. And you will see, paragraph 59, the report did not revert to the question of an express provision for hardship, and part 3 contains no express reference to hardship, injustice, or exceptionality.
Sorry, the reference again, please, Mr. Howard.
Sorry,
my fault entirely.
1199, paragraph
1199, thank you.
58 onwards. And I was starting at 59. I'll start again. Report did not revert to the question of an express provision for hardship. Part 3 contains no express reference to hardship, injustice, or exceptionality. Tendency in the family division in the Court of Appeal to regard hardship as a condition for the exercise of the jurisdiction. Pausing there, much of that is in the cases that Mr. Justice Mumby referred to that my learned friend went through. Rather than an important factor to be taken into account where it's present. So hardship, injustice is an important factor to be taken into account where it's present. And that feeds in, we say, into the mix of the considerations because Section 16 is not exclusive.
I could well see in the Ruritanian case, you might say, well, she should get exactly the same under this provision as it would have been if the financial relief had been awarded here in the first place, for example, irrespective of hardship.
That's what Lord Collins said.
Yeah.
Exactly what he said. There has been a similar tendency in the Court of Appeal to treat the element of exceptionality in the same way by saying the jurisdiction should be exercised only in exceptional circumstances. Paragraph 60. It is true that at least one of the purposes of Part 3 is to remit hardships which have been experienced in the past in the presence of a failure in a foreign jurisdiction to afford appropriate financial relief. Homes and homes. Well, pausing there, that's precisely what we say. it is a hardship not to have your needs met and to get less than 1% of the matrimonial resources. That is, on any objective view, a hardship. But hardship is not a precondition, so you don't even have to show that, of the exercise.
I can see it's an injustice. Whether it's a hardship may be more arguable.
Well,
I don't know if any members of the public, ever watch these hearings, but if they're told that 70 million is hardship, then they may have
Well, we say it isn't 70 million.
They may think they've
We do
tuned
say
into Ruritania.
We do say it's not 70 million. I mean, that's an issue. Secondly, that was determined as at 2007, and it was not reflective of what my client had in 2015, or indeed now. And as Lady Justice King said, it is all relative.
Well, it's not all relative.
No.
There are a lot of people in this country who are really suffering hardship at the moment. And it's important to bear that in mind when we're talking about whether it's 40 million or 70 million or 2 million.
Except that.
It's not hardship as it's generally understood.
No, not as generally, but of course it is hard not to get, I mean, as the law has now evolved, the wife is not a supplicant. She, prima facie, she is entitled to a sharing claim.
Well, I think injustice is a better description.
Right. Yes.
and the degree of injustice?
Well, the degree of injustice here is very, very considerable, we say. And that is a factor which we say goes into the mix and is balanced against, as we've always said, any small connection or lesser connection, because clearly if there is a very considerable injustice, all the more why you should not be precluded, because your connection is not during the marriage, which it definitely isn't here, and has only been, as of today, going for about 9 years. 61. The proposal in the Law Commission, I'm on page 1200 now, working paper, that the court should have power to order financial relief following a foreign divorce if the case would otherwise be one where serious injustice might arise, so it's unjust, was not followed through in the Law Commission's draft bill and finds no place. Lord Justice Thorpe was right to say in Jordan that injustice is not a necessary precondition, although they are not preconditions. Both hardship and injustice will, of course, be relevant factors for the court to take into consideration under both Section 16 and Section 18. So Lord Collins is saying in hardship and injustice gets taken into account under Section 16 and therefore on the leave application. The next question is on what basis the order for financial provision should be made. This is again a point that my learned friends have made, not amplified in oral submissions. The provisional recommendations of the Law Commission working paper were that English law should cover the principles on which a court granted financial relief. The court should be able to make any financial order it might have made in English divorce proceedings and should exercise its powers in accordance with the guidelines laid down in Section 25 of the Matrimonial Causes Act. Recommendation, paragraphs 56 to 57 and paragraph 67, recommendations 8 and 9. Those are references to the Law Commission's report. The recommendation was also made in the report and in the provisions of the draft bill, which became Section 17 or 18. So you do measure, we say, and it's important, you measure hardship, injustice in terms of English law, and you do ask the question, particularly as English law has evolved quite considerably, the wife is not a supplicant, that what is perceived as notions of fairness to a wife has moved on very considerably since 1980 and 82, and now a wife is entitled to a sharing claim for what was made in the marriage. And there's no doubt in this case, there's no grey area here. The parties were really absolutely without resources when they lived with my client's parents when they married, with no real money, and then during the marriage, my client was the homemaker. She worked in the business, she brought up 3 children, and as Mr. Justice Cohen said, she was a fully entitled wife and was entitled to, we say, as a starting point, 50% share. Now, of course, the connections, and we've always accepted that, may bring that share down at a final trial, but certainly she has a strong case under the matrimonial statute, which is applied by Section 18 and which also gets fed into the leave application.
Sorry, I don't quite follow that submission. Are you saying that because the court has the same powers
and same
to grant
and same
leave,
considerations?
So what are the same? Where's the same considerations provision?
Section 18. It's at the beginning. The statute, I think, is at the beginning. 916.
I see.
Section.
So this is based on Section 18.3, is it?
Exactly.
Yeah.
Section 18.2, the court shall have regard to all the circumstances of the case, first consideration being given to the welfare of a minor, as regards to exercise of those powers in relation to a party to the marriage, shall in particular have regard to the matters mentioned in Section 25.2a, A to H of the 73 Act.
Is there any difference between the two versions of these provisions that we've got at 920 and 2176?
I don't think so. Section 16.3 is in one and not the other. It's in this one. Yes. Section 16.3 applies in our case, but it won't apply to any case after we left the EU.
Okay.
So the second version, which my learned friend took you to, has not got Section 16.3 in, which is now gone. But if we were considering ground 12, we'd have to look at the version at 911.
Right.
So if you look at 18.3, and this must get fed into the leave application, Section 18. What this means is that the court has to take into account the resources which either party of the marriage has. And that is the fundamental difference as to A, why there's an injustice, and B, the difference between this court and the Russian court, because they did not take into account the resources that the husband has, because they ignored the beneficially owned assets. And as I say, they didn't decide that he should keep them, they just made no ruling on it. What they said is they are not part of what can be divided in Russia. And that is exactly the same as the lacuna, as we call them, in many of the cases. And I will come to that in due course, that actually almost all the cases under Part 3 are where there is a lacuna in the power of the foreign court. And that is the way it has been applied. But I sidetracked away from...
Well, a slightly different counterfactual would be if the husband didn't legally own any property at all, as opposed to some, so that under applying Russian law, the wife got nothing whatsoever because the husband had nothing. Everything was owned beneficially. There you would definitely have two things, injustice, and you'd also have hardship, in whatever way you like to describe hardship.
Yes.
And,
well, I've obviously...
it would come from the same inability or the same difference between English law and Russian law.
Yes.
It would emanate from that, as indeed every single case.
Yes.
In this area emanates from a difference between the law of the other state and the law of this state.
Well, that was my point, that if you look at the decided decisions, which I could summarise them at this stage, it may assist, but they are all what we would call lacuna cases. We don't use that word any more than in the common sense of a gap. It's a gap in what the foreign court can do, and gap, of course, was a word used by the Law Commission. It doesn't have any particular significance. But Agbaji itself, no power to order a transfer of property order. So they could not deal, the Nigerian court could not deal with what the wife wanted, which was the home in England that she occupied. So it's a gap. Schofield, which the reference is 1896, the German court could not deal with a very substantial asset, which was an English pension. It was an army man living in Germany, divorced in Germany, had a valuable pension, no power under German law to make a pension sharing order. And then there is AA and BB, which we've already referred to. The Slovenian court could not deal with non-Slovenian assets. And what's significant is the assets weren't in England. It's clear from the judgment, which we could look at in a moment, that they were not English assets. They were elsewhere. And there were no connection at all between this country and the parties until the divorce. The Slovenian husband, I think, was living in Dubai. He certainly wasn't living here. But nevertheless, between them, first of all, Mrs. Justice King, as she then was at first instance, gave leave. There was then a case whether she'd been misled. Mr. Justice Moylan said misled but not material, and confirmed the leave. And then that went to the Court of Appeal on other matters, and that's where it stood. And that is a complete lacuna case, because I'm going to use the word, but I don't use it in any, as it were, sense other than a gap. Then there is Jufali, and the page reference to that is 1532. And what happened there was that there was a talaq in Saudi Arabia. There was no possibility, as the judge found, of Mrs. Jufali seeking an award in Saudi Arabia, in the Saudi courts, and the reference to that is 1569. Then there's a case called Vasily Ava, which is 1293 in your lordship's bundle, ladies' bundle, where the finding was that there hadn't been full and frank disclosure to the Russian court, and there was no investigation, no opportunity to investigate the position. Then there's TNF itself. Now, there was an Italian woman. She was the one with the money. She did not live in England. The husband did. And the Italian court made no award of capital or maintenance. And as the head note shows, the husband had no claim under Italian law. And the wife's case there, which was given short shrift, as it were, on the set-aside, was much more formidable than here, because there were Radmacher relevances. The husband there had entered into a separation agreement, effectively a separation of property. So we had to get around that as well. But nevertheless, leave was given. And then there's the case, the recent case of Lockwood and Greenbaum, references 1254, and that's relevant for two things. Number one, the judge rejected the suggestion and the submission that there was a substantial connection requirement. He rejected that.
Sorry, can you give me the name again, or the reference?
Sorry, Lockwood and Greenbaum.
Thank you.
1254. And I may come to this in a moment. So there are three important things in that case. Number one, the judge rejected the submission that you had to show a substantial connection. And in fact, in that case, I think neither party were living in this country. And of course, the point has to be made that under the statute, you can apply if the matrimonial home was in this country and remained. So but they weren't even here. So there was actually no current connection at all. And why the English court took on jurisdiction was that there was no possibility of the New Zealand court taking account of the value of the London property.
Value of the
London property. London property, which was owned by the husband, I think.
Why is that not a connection?
So the point is that it was a lacuna case.
Oh, okay.
That's what I'm. Well, the connection in that case was the property in England, which was a matrimonial home. There was no other connection. Otherwise, it was a completely New Zealand case, certainly in the recent times.
But I think that the order was limited to that property.
It had to be because of the statute. What? There was no jurisdiction otherwise. The jurisdiction was based upon the statute, and then if it's on the matrimonial home, you can only have an order in relation to that home.
Oh, really?
Oh, is that right? Oh, sorry.
Section 15.
What? Section 15(1)(c).
Yes.
What? And Section 20.
Thank you. 20. Sorry, Section 20, did you say, where jurisdiction depends on the matrimonial home?
Yes. I thought it was 20.
Well, it starts by saying, or either party shall pay to the other such lump sum as shall be specified in the order. Is that limited to a lump sum connected with the house? Or?
It is 20, is it?
Yes, it says restriction of powers of court where jurisdiction depends on matrimonial home in England and Wales.
Yes.
20.
20, which is page 922.
Yes, there's a subsection 2, is it? That's limiting the lump sum to the value of the house. Yeah.
And the third point is that Mr. Justice Moore, an experienced judge at the coalface of these sort of applications, said that the leave test did not provide, as it were, difficulties, and there was a tendency to overcomplicate matters. And perhaps we can look at Greenbaum, which is it, as I say, 1, 2, 5, 4. And you can see in the head note in the 4th line, well, the husband and wife who had dual New Zealand and English citizens were married in New Zealand, thereafter lived in a house in England gifted to the husband by his father until they located permanently to New Zealand in 2009. So they'd been out of the country for 13 years by the time of this order. On the dissolution of the marriage in New Zealand, the wife was awarded maintenance, but the court was unable to take account of the value of the London property, which was outside its jurisdiction. We say a precise, as it were, parallel to here. Over the page, you can see it in the head note, about 5 lines up the bottom. It followed there was no precondition the court had to be satisfied that there were substantial connections with England and Wales, connection to the jurisdiction being merely one of the factors to be taken into account, and although listed first in section 16.2, was not given any primacy over the other parties. And then paragraph 8, you can see they relocated permanently to New Zealand. And although we were based on the matrimonial home, the court still had to look at connection. And the connection there was that they lived here for a short time. Paragraph 10, the 5th line, it's clear the New Zealand court cannot deal with assets that are outside its jurisdiction, which obviously included the property at Ringmore Wise. And then in paragraph 32, the learned judge said, the law in relation to a court dealing with an application pursuant to section 13 for permission to apply for financial relief pursuant to part 3 is in fact extremely straightforward. There's a real risk of overcomplication. I mean, this is a judge who will be dealing one of the specialist money judges in the family division who will be dealing with this day in, day out.
What paragraph is that, Mr. Hull?
Paragraph 32.
Thank you very much.
Paragraph 35. It follows this absolutely no precondition that the court must be satisfied that there are substantial connections with England and Wales. I'm entirely clear that paragraph 71 of Agbaji does not change the test set out in paragraph 33 of the same case. I accept Mr. Finch's submission that the reference in paragraph 71 to substantial connections with England is the need to pass through one of the section 15 gateways. The connection to this jurisdiction is merely one of the factors to be taken into account, and although listed first, is not given any primacy over the other factors. If I needed any confirmation as to this, I note that neither section 13 nor any of the authorities refer to the need for substantial connection as part of the test at the permission stage. And that is a recent case after Mr. Justice Cohen's order. And can we look, because I mentioned it, AA and BB, which is at page 1107. Because this, of course, is what I was referring Mr. Justice Cohen to when he stopped me at the ex parte hearing and said I had convinced him. I hadn't finished dealing with lacuna, but we said that that was a very important factor. So if we look at the head note on 1107, decision of Mr. Justice Moylan, as he then was, the Kosovan husband and wife had 4 adult children together and lived in Slovenia from 91. They established a successful company which now had a turnover of approximately 1 billion. Assets were held in Slovenia and in a number of other jurisdictions. In 2008, the wife and children moved to England, where they had since remained. The husband now lived in Dubai. So at the time of the hearing, been there about 6 years. The wife initiated divorce proceedings in Slovenia and sought maintenance for the 2 younger children herself. She also made a separate claim to establish the scope of and the parties' shares in the joint assets. She withdrew her claim for maintenance for herself, and orders were made for maintenance in respect of the children. In 2011, the Slovenian court dismissed the wife's claim in relation to the joint assets, those which were outside of Slovenia, as the court did not have jurisdiction to deal with them, and provided for the equal division of certain assets within Slovenia. Parties appealed, wife's claim fell to be reheard, applied for and was granted leave to pursue an application under section 13. In her application, she failed to inform the court that her appeal was pending in the Slovenian court. She asserted the husband had assets in the region of 68 million. The husband sought to set aside the grant of leave. And then in paragraph 4 deals with duty to make full and frank disclosure. Furthermore, it was clear that the failure on the part of the wife to refer in her application for leave to the fact that she'd appealed both the decision of the Slovenian court that it had no jurisdiction in respect of non-Slovenian assets, as well as the decision dismissing her appeal in respect of the Slovenian assets and ordering a rehearing of her substantive claim to a share of those assets, had been misleading. However, keeping that sense of proportion advised by the relevant authorities, this was not a case for setting aside the leave granted. The wife's claim was both substantial and meritorious. The test, obviously, substantial, given that the Slovenian appellate court had in fact held it had no jurisdiction to deal with the non-Slovenian assets, which was significant. This was not a case, therefore, where it could be said that leave would not have been granted. And then you can see the dates here, paragraph 2, 1109, 3rd of October, the leave hearing. So at that stage, she'd been in the country 4 years post-marriage breaking down. Paragraph 7, set-aside application. Paragraph 10, born in Kosovo. 91, they moved to Slovenia. Established a company in Slovenia. They remained living in Slovenia until 2008, when the wife and children moved to live in England. She and they have lived here since then. The husband remained living in Slovenia until 2010, when he moved to Dubai. At about the same time as she moved to England, the wife withdrew €5 million from an account in the parties' joint names in Austria. So, pausing there, pretty clear that's going to bring the end to the marriage. So the marriage came to an end when they were living in Slovenia in 2008. This led to the husband commencing proceedings in Austria, which were resolved in July 2000 when on appeal the wife was submitted to front. Then paragraph 15, the wife has produced a schedule of the assets held by the parties in 2008. It's only a summary schedule. It includes assets located in Slovenia and a number of other jurisdictions, including Kosovo, Switzerland, Ireland, Dubai and the BVI. So absolutely no assets in England. The only connection in that case was the wife moved here after the divorce. Paragraph 23.
After the breakdown of the marriage?
After the breakdown of the marriage.
But I think the divorce was sometime after she moved here, wasn't it?
Yes, but the breakdown of the marriage occurred in 2000. Well, my client, of course, says that the breakdown of the marriage here was 2013, whereupon she moved pretty speedily to this country. So if she's right, there's a parallel. Paragraph 23 confirms what the Slovenian court did. 24 explains that they didn't have power over non-Slovenian assets. And then paragraph 40 is about misleading the court, which I don't think I need refer to. Your lordships can obviously look at it at your leisure. And of course, paragraph 78, knockout blow, references to knockout blow and to the time which it should take for such a blow to be established demonstrate the nature of the test and the approach which the court applies to an application for leave to be set aside. The nature and the strength of the material required to be deployed is clearly significant. In the present case, the hearing took very substantially longer, 30 to 60 minutes. And then paragraph 84, was Eleanor King J misled? Deals with that. And then paragraph 85, however, keeping a sense of proportion as advised by Lord Justice Ward, I do not propose to set aside the grant of leave. Although it's open to the court to do so to protect its own process from abuse, to deter others, and to reflect its views of the nature of the extent to which the court in the particular case has been misled, I'm not persuaded this to be the right response. I've no doubt that I would grant the wife leave to make an application for financial remedy orders in the circumstances of this case, as they now are. It's undoubtedly a claim which is substantial in the sense explained in Agbarji. It is clearly not a meritorious claim, given crucially that the Slovenian court has no jurisdiction to deal with non-Slovenian assets, which appear to be very substantial in themselves. And that, of course, we say was something that Mr. Justice Cohen did not really properly take into account. It was the reason, substantially, why he granted leave. Could I go back, because I detoured on invitation into the area of lacuna, but could I go back to Agbarji?
I do apologise.
No, I'm quite happy to be. It's always good to go.
Yet again.
But I didn't want to be. I did want to come back to Agbarji.
Yeah.
But
in this case, there was an ex parte hearing and an ex parte order.
Yes.
Followed by a set aside.
Yes.
And that set aside was, in effect, an inter partes hearing.
Yes.
The basic proposition on behalf of the appellant is that it is unjust to exclude somebody. You have to hear the other side. There has to be an opportunity to hear the other side. And accordingly, the test on the set aside is incorrect. What do you say about that?
Well, we say, I was going to develop that at some length, but we say the test is perfectly appropriate. It was a considered test. Lord Collins considered the problems there'd been in set-aside hearings generally. He decided that the whole process of set aside had led to satellite litigation, delay, expense, and that one had to have a more stringent test. So it wasn't something that wasn't properly considered, which I could come to next. I'll go backwards in Agbaji. But the procedure has worked well now for some 11 years. As I know it, there isn't judicial complaint about the procedure, or indeed academic complaint, that really the situation here is that you have an ex parte application. Rather unusually, it is an ex parte application which is mandatory according to the rules, subject to the right to have an inter partes hearing. It has been the continuous thread of the way these matters have been dealt with since really the Law Commission. And once it got turned into a substantive set-aside application, which is what Traversa and Freddie lamented, then one had, and indeed Lord Collins, then one had long, expensive hearings. And if there was ever a case which illustrated, we say, the wisdom of the guidance by Lord Collins, it is this case and the figures involved. And here we are. My client made her application 5 years ago, slightly more than 5 years ago. And she really hasn't moved forward an inch because we have got bogged down in satellite litigation, in which, of course, the husband has persuaded courts that they should be investigated matters that fall to be investigated at the final hearing. Whether she is a forum shopper, whether, of course, the Russian law was applied properly, whether, of course, her connection is based upon, as my Lord Legate said, some sort of charade and she's just here out of convenience. All of that can be investigated. And, of course, whether or not, and it seems to be accepted, she had any opportunity to have a needs-based claim in Russia. It seems to be accepted. She doesn't. And we say that the test was well thought out, it was properly considered, and there have been problems which have been referred to in the authorities, and that it was the right procedure. And, of course, it was in line with the overriding objective, we say.
When there was reference in Bargy, I think, to, or maybe it was in the Court of Appeal case, to a practice having grown up of having hearings ex parte on notice, as they used to be called, were people still then, after that hearing, applying to set aside? Was that part of the mischief?
As I think Mr. Leach told the Court of Appeal, and I think it's in my learned friend's position, more recently, inter partes hearings have been very, very rare. Mr. Leach said that to the Court of Appeal. So Traversa and Freddie did stop, effectively, the practice of giving informal notice.
Yeah, but I'm just interested in whether part of the problem at one stage was or wasn't that people who were being notified of the ex parte hearing, so they had a chance to turn up and say their bit then, were then also seeking to set aside and have longer, or did that not happen?
No, because
did people only have one go?
Leave application.
Sorry?
They were given notice of the leave application. Yes. So there was an inter partes on notice. So there was an inter partes hearing on informal notice, contrary to the rules.
That's what was happening at one stage.
That's what was happening. That's what Traversa and Freddie talked about, is actually a practice was grown up whereby family practitioners, as often there won't, ignored the rules. And they started giving informal notice to the other side, who no doubt would turn up. But there was no justification for that in the rules.
No.
And Lord Justice Thorpe said, no, stop it.
If they were given informal notice and didn't turn up,
yeah,
could they then apply to set aside?
Well, I think that would have made it possible. I mean, that may have been the reason why. I mean, you're probably asking the wrong person, because I never made an ex parte application. I never gave notice. So you're asking the wrong person. But that would have made a set aside presumably more difficult, and that may be why family practitioners did it.
Yeah.
It may be, but
I have to be honest, I'm speculating.
What you say is that now the practice is that it really is ex parte. The respondent doesn't have an opportunity to attend or
Yes.
make submissions. Then, once leave has been given, they can apply to set aside, but the only basis that they can rely on to set aside is broadly that the court was misled at the ex parte application stage, and the AA and BB shows that even if you do manage to show that the court was misled, that won't necessarily result in the leave being set aside.
Well, it's got to be material. I mean, one example of that was the Court of Appeal saying that what my client stated wrongly about the maintenance for the youngest child here was not material because
So what is the test then? You have to show that there was a misrepresentation given to the court, or the court was misled in some way, and that what the result would have been different, the result might have been different. What is the test that you're saying is the correct test for the court to apply when being asked to set aside leave granted at a truly ex parte hearing?
well, number one, a decisive authority has been overlooked.
Yeah, but
So if you made an application to a new family division judge who'd never practiced in the family division and you didn't mention Agbaji, you're in trouble, obviously, because that's a decisive authority you haven't drawn to the attention of the court. There might have been other decisions that...
all right, but just focusing on the misrepresentation.
But that's...
Facts.
Don't forget that.
This is where with ex parte applications generally, all the argument when you do have this is about, how far the duty of full and frank disclosure went, whether this fact would have made a difference, or those sort of things.
So
I mean, clearly, if you mislead about connections, it will be set aside.
But what are you saying in answer to my lady's question is the test of materiality?
It's the testament, yes. It's got to be material to the leave.
Well, does that mean it would have been different, or it might possibly have been different? Or might have been different? It might well have been different?
Well, I think it is fact-specific, but I mean, clearly it has got to be highly material to the decision. I mean, obviously, the big one would be connection.
But if
for instance,
the court decides that the ex parte judge was misled and it was material,
yes,
do they then automatically set aside leave, or do they then consider again at the set-aside hearing whether leave should be granted now that they have the full picture?
The latter.
Well, there are some cases, aren't there, where the misleading, certainly cases about the failure to comply with the duty of obvious good faith on ex parte application, where you lose whatever relief you were asking for without regard to the merits.
Yes, and
If it was deliberate, let's say that would be the result.
I mean, if my client, if someone tells a deliberate lie about her connection, and I mean, which is extremely serious, then not only might the leave be set aside, but she might, the ex parte leave, but she might be prohibited, her whole application might be dismissed.
Yeah.
But that's only if there's a deliberate lie, you think?
Yes.
So
Well,
if
I mean,
there's something less than deliberate lie, which was made to the ex parte judge, the court hearing inter partes, hearing the set-aside, thinks, well, it may well have had made a difference, or it would have made a difference, but nonetheless, I can consider it afresh and still grant leave. Is that?
Yes. I mean,
Which is what the judge did in this case.
Which is what the judge did in this case.
Yeah.
But I mean,
What I find hard to see is why on the set-aside application, instead of spending the short time that you're meant to spend in deciding whether there's solid grounds for granting leave, you spend the time arguing about what wasn't said at the first hearing and whether that was material. Yeah. That seems to me not only a procedure that I think is contrary to fairness in the way it operates, but also contrary to efficiency.
well,
And not really calculated to create good decisions at the leave stage.
Well,
if it depends on, on how thorough council were in making the application in the first place, and other questions of whether it's a good idea actually to let this go to a hearing are very much subsidiary.
Well, I may develop this tomorrow, but the position is that we say that actually what you can say on the set-aside is limited, and it's also limited what you could say on the inter-parties, and there is not a lot of difference, because it is quite clear that what is mandated here is an ex-parte procedure, subject to the right to consider inter-parties. Now that is based, we say, on what I read out from the Law Commission's report, that the leave application is not meant to be the trial of the century. It's not meant to be trying what occurs under Section 16. It's whether you've shown substantial grounds, i.e. a prospect of success. But it is based upon your uncontroverted statements. It is not an opportunity, either at an inter-parties hearing or a set-aside hearing, to start saying, oh, well, I don't agree with what she says there, and there, and therefore there shouldn't be leave, because that is what is going to turn these applications into long satellite interlocutory hearings. Obviously, if what is said in the statement in support is palpable nonsense. I mean, to give an example, my client said she intended to live here and nowhere else from 2014. That was an averment. If the husband had had in his possession a letter from her to say to one of her children, which said, well, actually, I think I've got my best chance of getting some money in England, and I'm going to say I'm going to live there, but actually I really want to live in California, where I've got a house and I'm not going to tell the court about it. Now
that's an extreme example, which is not terribly helpful.
But it is sort of what the husband said here, if you look at the beginning of his statement. He says this is divorce tourism. He makes that allegation in the first part of his witness statement. This is divorce tourism of the worst sort. And that was his case.
But there's a difference between controverting the facts and making some focused submissions on what weight should be given to the factors in the Section 16, for example. I mean, when permission is... It may have been different when Akbarji was decided, but nowadays, when you apply for permission to appeal to the Court of Appeal, the respondent is encouraged and permitted to put in some short representations. And I used to find that very helpful in focusing my mind when I was deciding whether to grant leave, consider what the respondent said in answer to it. And I might quite often have decided not to grant leave when I saw that, whereas if I'd just been persuaded by the blandishments of the appellant, I might have thought that it was sufficient. And I don't see what's wrong with giving a party an opportunity to be heard at that stage.
Well, as Mr. Justice Moss, to answer that point, was recorded as saying in Traversa and Freddie, it was quite a usual practice for, even before there was a specific rule for people to for respondents to make submissions to the Court of Appeal. Certainly that's been going on for a very long time and before Akbarji. So,
well, once you've had the chance to do that, obviously I can understand why you don't have another go after that unless there's compelling reason. But if you've not been afforded that opportunity in the first place, why shouldn't you be afforded that opportunity in the second place before the thing goes ahead?
Well, because, yes, you can have the opportunity, but you've got the opportunity on the set-aside. Because my submission is that really what you can say is you've been misled and I can show it. Not just an averment, but I can show it. If you just say, I don't agree with these 30 factual averments, well, you can't resolve that at either the inter-parties or the set-aside. So your opportunity is pretty similar, either because it's quite clear it's based upon the evidence of the wife, and you assume that she's telling the truth, unless you can demonstrate, not just aver, demonstrate she's been misled. Then it takes you into authorities. I mean, if it could have been said that I had misrepresented AA and BB, which I relied upon, then they might have got somewhere. But it's interesting that when we got to the set-aside hearing, what Mr. Bishop said, he said that AA and BB were contrary to Agbaji, and it was per incuriam. He didn't say that I'd misrepresented it. Those are the sort of submissions for the final hearing. And we would say that if you were, I mean, it's not just this case, as we've made clear, one wouldn't want to change the test just on this singleton, rather exceptional case. But even if you take this case, what really did the husband say on the set-aside, which he would have said on the inter partes? And we say there isn't anything.
Whatever he said did persuade Mr. Justice Cohen to change his mind.
Yeah.
Yes.
Judges do sometimes when they hear, if they only hear one counsel, however fair the counsel is, of course they can make the case rather more effectively and more likely to persuade the judge than if the opponent is allowed to turn up and just perhaps make a few short, punchy points.
The position is here, the ex parte leave application order was made. Mr. Justice Cohen, in his judgment, referred to, well, the husband can set it aside if he's got a knockout blow. He actually said that at the end of the judgment. We then get the witness statement. The application from the husband did not set out the grounds, it said statement to follow. We then get to his witness statement, and it was based upon the court was misled. That's what he said.
Well, that's because everyone was proceeding on the basis that that was the test.
Including him.
Yeah.
And then when one got to Mr. Justice Cohen, Mr. Bishop put it on exactly the same basis. He was misled. He didn't say the test was wrong. He didn't say he was having his say on the set-aside application.
Well, he probably thought he couldn't say the test was wrong at that level, but that's what we now have to grapple with.
We now hear that it's overture, so he could have...
Yes, but for him it was caught by binding Court of Appeal approval.
Yes. Yes, but the Court of Appeal weren't addressed on that either. But I mean, the whole thread of this case was that the paragraph 33 guidance ruled the situation. And when one got... So when it came to Mr. Justice Cohen on the set-aside, the first part of his judgment is, I'm going to set aside the leave because I was misled. Yeah. And he made, we say, findings of fact, evaluative findings, which were not part of a discretion. The Court of Appeal were in an equally good position to look into that. It's not part of the grounds of appeal, as my Lord Stevens pointed out, and the whole argument before him was misled. That, then, of course, having been misled, we start again. And, of course, we say that there's nothing that was considered, could be considered on the leave that wasn't considered by Mr. Justice Cohen when he gave ex parte leave. I mean, if you look at his judgment, he fed everything into the mix. He fed in the weakness of the connection with Russia during the marriage. He had a schedule of how long my client had lived here. He did not ask for a schedule going back before 2016. And then what happened was, we had a directions hearing. We said the 3-day hearing is not proportionate. It shouldn't happen. He was not persuaded. We went ahead with the hearing. But what is particularly unfair to my client about all this is that he confined her ability to answer what the husband said to financial misrepresentations. He refused leave to put in 2 statements that she wanted to put in to answer what the husband had said. And then when we came to the set-aside hearing, which is why it was unfair, he made findings of fact against her. And he made 3 important findings of fact. One, that her connection was recent and modest, which does not sit well with what he decided at the ex parte hearing. He made a finding that she was a divorced tourist, which we say was totally unjustifiable, without her having any ability to answer what the husband had said, and that there was a proper application of Russian law. And your ladyship asked about what the expert evidence was that in paragraph 51 that Lady Justice King was referred to, it was clearly on Russian law, if you look at paragraph 87 of the Court of Appeal judgment. So,
Sorry, what did you say the third finding was?
there was a proper application of Russian law.
Yes, thank you.
I find it quite hard to see why first instance judge in the family division is deciding whether the Russian Supreme Court has decided its law properly or not, but there we are.
But it was part of his finding on misleading.
But it seems extraordinary that that's an issue in these proceedings.
Well, I mean, we said that it wasn't a proper... I mean, we didn't major on that at the ex parte hearing, but it was part of my client's case. And he wouldn't even hear argument on that. At the set-aside hearing, he refused to look at one of the... As you can see from his judgment, he refused to look at one of the decisions. But, I mean, our primary case was that none of this should have been at the set-aside hearing. It should have been an essential summary hearing for you to say... where has Mr. Justice Cohen gone wrong? And if one looks at his judgment, which is at because what I invite the court to say is actually that inter partes, what the husband had to say in his witness statement would have made no difference to that, as it should have made no difference at the set-aside. And you can see it starts...
How is he supposed to apply to set aside this judgment? I don't understand. I mean, has anybody ever succeeded in setting aside leave granted at an ex parte hearing on this on this test?
What? Well, Mr. Nagpal has in an unreported case. I think M&W it was granted.
Because I can see that, you know, if the argument was, oh, well, you didn't refer him to an important authority, the answer would be, well, he's a very experienced family law judge. Of course, he or she knows all the authorities. They don't need me to point the do. I mean, I just don't see how you can win on the test.
Well, occasionally somebody probably comes along and tells a lie or conceals some fundamental fact deliberately, and then they lose, I suppose.
And you can ascertain that.
But
I mean, it's not unknown in the family division for people, you know, I mean, in the same way that people have been found to tell lies on ex parte freezing injunction applications. And then the husband, or if it's the other way around, the wife comes along and says, well, I mean, I know you don't make decisions now, but really that's palpably wrong because of this document.
Yes, but freezing orders are routinely set aside at the inter partes hearing without having to prove that there was a deliberate lie, just that when the judge hears from the other side, the case takes on a different complexion.
I really feel that the fact that the basic considerations here have not been challenged is sort of slightly being turned against my client. I mean, there are lots of things that the husband could have said. He could have said, for instance, well, actually, I'm not the beneficial owner of these assets. He didn't say that. He could have done. He could have
presumably
said...
not in this case.
What?
Presumably he couldn't in this case, unless he was going to come along and lie in the court.
As I say, just because... I mean, my point is that actually... I mean, one has to focus on this case. That actually, on a set-aside application, if you take away the allegations of misleading that were made and were ruled upon, and there's no rational criticism of the way the Court of Appeal dealt with it, you aren't left with anything. And therefore, there was complete fairness here, because if you look at what Mr. Justice Cohen decided, then there really wasn't an answer to it. I noticed the time.
Well, if that's a convenient
Well, I was going to go
point, Mr. Howard.
go through the judgment, so...
So if you're turning to a new topic, then...
Well, it's not a new... I mean, I could spend 2 minutes just on the judgment on that point, but I'm quite happy to finish.
Well, if you're not pressed for time, we'll resume
Fine.
tomorrow morning at 10:30, please.
Thank you.
Thank you all very much.
Thank you very much.